Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and this week's contract tip has to do with the closing attorneys sharing the closing disclosures with agents at closing. That's a lot of closings. Hopefully you guys are all having lots of closings. Anyway, just a quick little tip to go over what is in the contracts. In the actual GAR contract, the 2016 GAR contract form, they have added on page 1, GAR has added a paragraph. It is paragraph A13, and it says consent to share non-public information. So let me read that to you. Buyer and seller hereby consent to the closing attorney preparing and distributing an American Land Title Association, ALTA, estimated settlement statement combined to buyer-seller, brokers, and brokers affiliated licensees working in this agreement for their various uses. So that's in the GAR contract. And the buyer and the seller sign it, and basically what it is saying is the buyer and the seller consent that the closing attorney can share that combined closing disclosure. There is another form of that Andy Hartman of Hartman and Briali shared that says, I'll read that one to you, that you can use as a special stipulation, and it states, by executing this agreement, the buyer and seller expressly authorize the settlement agent / closing attorney's office and the buyer's lender, loan officer, and their staff to discuss, disseminate, and share 1, the closing disclosure, 2, the seller's disclosure, and 3, any other settlement statements and sources of information with the other parties to the transaction, such as the real estate agents, brokers, and other parties to the contract. The buyer understands that some of these forms may contain non-public information as defined by the TILA and RESPA federal laws, such as the buyer's loan terms and other credit information. The buyer acknowledges that the buyer is not required to consent to or grant this authorization. However, this authorization is being given in order to facilitate the exchange of information necessary for other parties to the transaction to ensure that all terms of the agreement are being followed and incorporated, and to help produce a closing on the target closing date without unnecessary delay. The buyer further acknowledges that no closing disclosure, settlement statement, or other document containing terms of the settlement statement or loan costs may be relied upon as accurate or legally binding unless such statement or closing disclosure is delivered directly to the buyer from the lender. So again, there are those statements, the one in the GAR contract, the other one, special stipulation, you can use. And in the loan exhibits, there are also statements that the lender agrees to share information with the agents regarding what's going on with the processing of the loan. Now, a couple of issues. Number 1 is these new federal laws are governed by the Consumer Financial Protection Bureau. This is a government agency who they are not a budgeted line item. Their only source of funding is from fines that they get from levying on closing attorneys and mortgage lenders. Therefore, they are looking for mortgage lenders and closing attorneys to be out of compliance with the new laws to help sustain themselves as an organization. So my point in telling you this is it is a great effort for the contracts committees, both the RE Forms Contracts Committee as well as the GAR Contracts Committee, to put these statements in these contracts and in the exhibits. And even if the buyer and the seller sign it, guess what? The closing attorney and the lender do not sign your contracts. And so just because they are signed by the buyer and the seller does not necessarily mean that you are going to get to a closing attorney or a lender and they are going to necessarily willingly share these closing disclosures with you guys. They aren't required to. It's not their signature on the contracts, and they are more governed by the Consumer Financial Protection Bureau and don't want to be fined out of business because those are the new laws to which they must adhere. So what do? Well, the easiest thing to do, we can get copies of the seller's closing disclosure. And of course you need that for closing to turn into your broker, because that's where it has the commission outlined. The issue is getting the buyer's side of the closing disclosure. That's where the earnest money issues are, any other buyer concessions, and information such as that. So what do? Because the closing attorney and the lender can't share it with you guys, but guess what? The buyer can. The issue is you need to set that expectation with the buyer up front, not at the end of the deal when they first get it, because then if you tell the buyer, well, I really need you to share this with me because the closing attorney and the lender won't, then the buyer starts thinking, well, what is it? Maybe I'm not supposed to share it either. But when you first work with a buyer, when you first sign them to a buyer agency agreement, if you set the expectation then by letting the buyer know, hey, Mr. and Mrs. Buyer, really excited to help you. Once we find the house, write a contract, get through all the negotiations. As we get closer to closing, you are going to receive a document from your lender that's called a closing disclosure. And that is going to outline all the finances for you and everything per the contract that we have just negotiated. So when you get this, go ahead and please share it with me so that we can go over it together. Number one, so I can make sure that you understand everything and where every penny is going. And number two, so we can make sure that there are no mistakes or correct them in time and make sure that everything, all the finances are being allocated as they were negotiated with the buyer and the seller. So again, I'm going to remind you closer to closing, but you will get this at least 3 days in advance prior to closing. And when you get it, just simply send me a copy of it and we'll go over it together. And if there are any issues, I will be more than happy to share it with the listing agent as well, just to make sure that we're all on the same page. That's all you have to do. You set the expectation up front. It has not been an issue until the TRID laws came into effect and all of a sudden buyers have stopped sharing. Now, the purpose is to not necessarily share the buyer's loan information or interest rate, because the seller doesn't need to know that. But guess what? A buyer doesn't need to know the seller's payoff either. So kind of goes both ways. And some of the closing attorneys on this ALTA settlement statement, some of the closing attorneys are having an issue with sharing that as well, because the purpose of the CFPB is to protect that buyer's consumer information. Well, on this combined settlement statement, it has information regarding the buyer's interest rate, and if you do, or regarding their payment, and if you do a little bit of calculations, you can figure out the information that they're trying to protect. So again, just wanted to share that with you, and a little bit of a tip on how to talk to a buyer up front to be able to get that closing disclosure that you do need so that you guys can make sure that it is properly done and does reflect the actual negotiated terms between the buyer and the seller. Thank you so much for watching. Again, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.